Hi guys, welcome to my channel once again. This is Battle with Ola. My name is Mujula. Thank you so much for stopping by the channel once again. Today we want to talk about wills and codicils. It's a very important and very controversial topic, and I'm so glad that I got to shoot this video finally. Today we are going to be digging into wills, what it is all about, and trust me, whether you're a layman, a lawyer, or a law student, this is going to help you. If it gets too long, I might cut it into part 1 and part 2, but if not, we could have it all in one video. I hope you stay tuned till the very end. Please don't forget to subscribe to the channel if you haven't, and if you do like what you see after you've seen this video, kindly give it a thumbs up. Thank you so much. And don't forget to spread the word. Please spread the word. Tell your friends, tell your foes, and tell everyone that you can about this channel. Thank you so much. Let's talk about wills and codicils. Making your own will gives you the latitude to dictate how your property will be managed after your demise. Making your own will makes sure that all other laws or customs or traditions that would have come into play are vacated. That means that if your family has a tradition by which they divide family property once a person dies, or they share properties of belonging to people who die in the family. Once you've made a will, they can no longer apply those customs and traditions, because your will take effect, and your will superimpose on all other traditions or customs. Another benefit of making a will is that you could even give instructions as to your burial. Yes, I have made a will whereby for a client now, whereby he gave instructions as to how he wanted to be buried, where he wanted to be buried, and he even made financial provisions as to how what should be spent on his burial and where the funds are to come from. So he made all of that. So a will allows you to do that. Another benefit is that it's supposed to be cheaper than dying intestate and having to apply for letters of administration. Although in today's Nigeria, with all the bureaucracy and all the corruption in the legal system, I'm not sure if that's the case, but ordinarily it should be cheaper than obtaining letters of administration, cheaper and faster than obtaining letters of administration, except where the will is being contested, or the validity is in question. So it should be cheaper. It's supposed to be cheaper, and more time saving, more decent, and just tidy, for your property to be administered, to be executed, to be managed and distributed the way you want it, than people, family, next of kin having to apply for letters of administration. Then a will can serve as a documentary evidence. Your will can serve as a documentary evidence. If you do not make a will, then there's no evidence for you should you need such type of evidence for any purpose. Then a will allows you to appoint guardians for your infant children in case of your demise. Then it also allows you to endow trust funds for charity organizations, for your own children, and for whatsoever purpose, for whatsoever lawful purpose. You could also do that with your will. And lastly, a will ensures the continuity of your estate. So a will preserves your estates in a way that letters of administration might not be able to. So for instance, if you have a law firm, if you had a law firm in your lifetime, or if you had a bank in your lifetime, or if you had a company that you solely founded in your lifetime, once you make a will as to how it is to continue or be managed after your demise, business can continue. It can remain a going concern according to the dictates of your will, instead of you dying and then people scampering here and there, and people trying to sabotage you, to usurp what you've done, fighting themselves over who takes over the reins of the company or the property. So these are some of the benefits of making a will, so you should consider it today. Now let's talk about testamentary capacity in making wills. Testamentary capacity is divided into two. I've mentioned it earlier. That's the age and the mental capacity. So a testator must be of the lawful age. Under the Wills Act, the age is 21 years. So once you're 21 years under the Wills Act, you are allowed and permitted to lawfully make a will. If you make a will before this age, when you attain this age, it does not validate the will. The will remains invalid. And under, the Wills Law of Lagos State, it's 18 years. Once you're 18 years, you can make a will. So you should check the law governing your state of domicile, or the law under which you have chosen or elected to be ruled. So once you make a will under that law, you have to be sure that you are of the lawful age to make that will. So that's the age, that's part A of testamentary capacity. Now, some people are allowed to make wills without necessarily attaining that age, and they come under the privilege will. And some of them are, mariners at sea, crew members, seafarers, crew of airlines, and military servicemen. So you know that before some of these people, start work, they are not yet of that lawful age, that age of adulthood. So if they are already in this employment or service, they are allowed to make a will even if they are not of the lawful age of 21 or 18, as the case may be. Now, testamentary capacity. B. The B part is mental capacity. A person making a will has to be of sound mind. This is one of the most disputed, requirements for making wills, because the sound mind has to be present while they are making the will and at the point of signing the will. So a person has to be of mental capacity when making the provisions for their will, for their estate, and when they are signing the will. So if they made the will, for instance, with sound mind, and then when it's time to sign the will, they are no longer of sound mind, the will becomes invalid, and it can be contested even if it's registered, deposited, and still preserved as their will. It can be contested much later. So it's important, mental capacity at the time of making the will and at the time of executing, that is signing the will. The testator must be of mental capacity. There are so many decided cases, establishing, what to look out for to decide if a person if a testator is of sound mind or sound disposing mind in making their will. And but in Banks and Goodfellow, some steps were laid down. You have to establish the fact that, one, the testator understood the legal implication of making a will and had the intention of being bound by that will when making the will. Then two, they have to understand and know the actual extent of all the properties being disposed of in the will. That is the properties that they are giving out, the gift clauses, the items contained in the gift clauses. The testator must understand and know the extent of those properties. And three, the testator must know the beneficiary, must have sufficient knowledge of the beneficiaries that they are giving us their properties to in the will. And then the last thing is that the will must be rational. If a reasonable man, an ordinary reasonable man, should read the will, it should not, they should not be smelling a rat. So the will should be rational. And there are so many other decided cases and other ways by which people have tried to ascertain if a testator was of sound disposing mind while making their will. If the sound mind, the sound disposing mind of a testator is being contested, usually the onus is on the propounder of the will, that's the person that put the will forward, to prove that the testator was actually of sound disposing mind when they made the will and when they executed the will. And then the onus now shifts to the challenger, that's the person disputing the will or disputing the sound disposing mind of the testator, to now prove that the testator was not of sound disposing mind when they made or executed the will, as the case may be. Now, blind persons can make their own will. Once a blind person's jurat is attached and the will, it is ascertained that the will is read over to them, they understood the content before affixing, their signature or their seal or their hand to the will. However, a blind person cannot attest to another person's will. That is, they can't sign the will of another person because it is presumed that they would not see the signature of, they cannot see the signature of the testator, which they should confirm that the testator actually signed under their own hand before they witnessed the will, before they signed the will. So because they cannot do this, they cannot sign as a witness to another person's will, but they can make their own will. So how do you establish the validity of a will? There are four important factors considered in establishing the validity of a will, and they are quite similar, if not the same, with the features of a formal will. They are as follows. One, the testamentary capacity of the testator must be established. I've already said that testamentary capacity just means that lawful age, the testator is of lawful age, and of course they are of sound mind, sound disposing mind. And then two, the will must be written. It must be written. And then three is that the will must be made voluntarily and without undue influence. Now there are so many decided cases as well regarding undue influence. It must be established that the person that made the will, the testator, made it voluntarily and without any undue influence. And of course, the last thing is that it must be duly executed according to Section 9 of the Wills Act. It must be duly executed according to Section 9 of the Wills Act. Section 9 just provides, the how, the where, and, the who for executing wills. So it provides for, the testator must sign. The testator must sign before the witnesses, and the witnesses must sign, and they must sign at a certain place, in a certain manner. And these are some valid means of signature or types of signature or sealing that is allowed, or execution that is allowed, and all of that. So you could look up Section 9 of the Wills Act. It just provides for how execution is to be done, and once it is done accordingly, it is valid. It is a proof of validity of a will. Beneficiaries cannot attest to wills. That is, if in the will they've given you something, you cannot sign the will as a witness, because it's just fishy. Normally it's fishy, to say that you're also signing a document that is purportedly giving you something. I mean, it sends a wrong signal. So it's important. Witnesses should preferably, in real life, they should be people that are not getting anything from the will, and preferably they should even be people that have no connections with the beneficiaries of the will, so that once they sign, they will not want to tell your wife that, your husband gave you Prado, he didn't give you Lexus or something like that in his will. So it's important to allow people that have a minimal or no interests in the will or the gift clauses in the will to attest to the will. But where beneficiaries attest to the will, that means that they have to fulfill the gift. The gift becomes null and void. Now, if your spouse, for instance, is not a beneficiary, they can sign. But I mean, how will it look? How will it look? So, generally, it's just safer and easier, smarter to get people that are in no way connected to the will or the benefits therein to witness the will for you. Let's talk about the types of gifts that can be given in a will. And they could be legacies or devices. Devices are usually immovable properties such as land, house, and what have you, while legacies are movable properties, goods, chattels, books, monies in bank, shares, and all of that. They are called legacies. There are different types of legacies, so let's just go over them one after the other. The first is specific legacy. Specific legacy is a gift in a will that is very specific. E.g., I give my Toyota Carina with registration number A20024C to my daughter Shade. That is specific. The gift, the legatee, and the legacy are specific. That's a specific legacy, a specific gift. Now, legatee is the same thing as beneficiary. Just means the person receiving the gift, the person receiving the benefit, the person receiving the legacy in the will. It's called a legatee. Then we have general legacy. General legacy is a legacy that's not specific. So, for instance, in one Papa Ajasco that I watched when I was young, someone died. A chief died, and then Pa James was given I think 2 cartons or 2 tins or 2 sachets of Panadol Extra, since he was always complaining of headache during the lifetime of that uncle that died. So just said, For instance, you could just say, oh, I give Pa James 2 sachets of Panadol Extra. So they could walk up to any pharmacy, buy it, and give it to Pa James. There's no specification. So it could be, oh, I give a rechargeable standing fan to Tola, or to my son, or to my daughter. So the gift, the legacy is not specific. They could go to the market and buy any rechargeable standing fan and give it to Tola or to the son or daughter. Then we have a demonstrative legacy. A demonstrative legacy is a gift that not only describes the gift and the legatee, but also the source. For instance, I give £20 to my daughter Tola to be drawn from my first bank domiciliary account, or to be drawn from my first bank pounds denominated account or pounds domiciliary account. So you already know that that £20 is coming from a particular source. That's the domiciliary account with First Bank. So you already know that nothing can happen to that gift in most cases, except there's no money in that account. Another instance, because it's not just money, it could also be, oh, I give all my books published by what's a big publishing house now? University Press PLC to my son Olu. So you already know that that gift is going to come from all the books published by University Press. So it shows you the source of the gifts. Then we have pecuniary legacy. Pecuniary legacy just means that monetary legacy. So it could be any of the legacies we've talked about. The essential distinction is just that it's money. Now it could be an annuity where it's to be paid, at a prescribed period, probably yearly, and it could be general, it could be specific, it could be demonstrative, but essentially it's money. That's why it's pecuniary. And then we have residuary legacy. Residuary legacy just means that the gift is going to come from the residue of something. So for instance, a testator could say that, oh, use so and so and so from my bank account in this bank for the burial, and then whatever is left in that account, give it to my auntie Feishara. So that means that the residue after the burial has been conducted and the expenses deducted from that account is going to Aunt Feishara. So that's a residuary legacy. Then we also have absolute legacy and conditional legacy. As the name implies, absolute legacy just means that, no conditions attached. So straight away, you give it. Then conditional legacy means that upon, the fulfillment of certain conditions. So someone could say that I give my Jaguar, my Ford Jaguar 4-wheel drive to my daughter Tunde if she passes her call to the bar examinations at once, at one sitting. So that's conditional. But if there are no conditions attached, it's unconditional. So very easy, very simple. So those are the types of gifts. Now I want us to talk about ademption. Ademption means that a specific gift now is no longer in existence, so it can no longer be fulfilled technically. For instance, if someone gives all the books in my library at my office to so and so person, and maybe the testator's office gets burnt and all the books get burnt. So the gift itself is no longer in existence. So there's no way for that gift clause to be executed or fulfilled. So that is ademption. Ademption means that, it's been overtaken by events. The events being the non-existence of the gift item anymore. And conversely, we have gift lapse of gift. Lapse of gift is where the beneficiary or the legatee predeceases, the testator. So someone has given, for instance, what was given to Auntie Feishara. Now let's say that Auntie Feishara now dies before the testator. She's no longer capable of receiving that gift. So we say that the gift has lapsed. So that is lapse of gift. The will can be revoked, can be republished, and can be revived. The 3 R's. Revocation just means that, invalidating the will. It can be revoked by law or voluntarily. Where it's voluntary, it's by the act of the testator. For instance, a testator could make a codicil, revoking a validly made will. Then the testator could destroy the will with the intention of revoking it. And the testator could, make a statement, a declaration, that they are revoking a validly made will. Now, a will can also be revoked by law, and that's, for instance, where the testator was married to someone under the customary law before, now marries another person under the act. That's a statutory marriage. It revokes the will made, by that person earlier. So, but if they are marrying the same person now, maybe they've done traditional wedding before, and now they are doing they are doing a statutory wedding or marriage. Now, if it's the same parties, it does not revoke a will that's been made before. But if it's different parties, it does revoke, the will. Now, republication just means giving the will another date of operation. So, a validly made will can be republished, giving it a new date, the date where it is republished. And then a will can be revived. That's if a will was formally revoked, it can be revived. And there are certain conditions that the testator has to fulfill, but, they can still revive, a valid will that has been earlier revoked. Those are the 3 R's. Take note. Let's briefly talk about codicils. I mentioned it earlier. A codicil is a supplement to a will. Now, there can be a codicil after a will, but there can be no codicil before a will. So, for a codicil to exist, there has to have been a will, a validly made will before it. So, a codicil can serve to republish a will, to revoke a will, or to revive a will. And the characteristics of a will and a codicil are they're similar. So, they're similar. That's the testamentary capacity of the testator in a will has to be present in a codicil as well. And of course, a codicil has to be attested as well, duly attested according to the Wills Act. So that's what a codicil is. A codicil can amend the will. It can have supplementary provisions added to a will, and it can revoke alters or provisions of a will. It is essentially a supplementary document, a supplementary will to a pre-existing will. But where a testator has been making several alterations, it is advised that they make a fresh will instead of making codicils upon codicils. Also, where they have contracted a statutory marriage, a new statutory marriage, it's advised to make a new fresh will rather than a codicil. Also, where there's been a change in their financial status or in the status of the gift items in the gift clauses in the will or codicils, it's important to make a fresh will altogether. And also where a testator changes their address or their residence now, it's important to make a fresh will and not a codicil. Wills are governed by the laws that I've stated earlier. So if a person is not governed by those laws, they cannot make a valid will. If you're rather governed by the Islamic law, you have to make your will according to the dictates of the Islamic law, not the Wills Act or the Wills Law or what have you. Also, if you are governed by the customary law, you have to make your will according to the dictates of the customary law. The Wills Law, Wills Act, and all those other laws will only govern those who have elected in their lifetime to be governed by those laws, clearly and unequivocally. Once a will has been made, it can be kept or deposited at the bank, at the court registry. The testator can keep it, or they could keep it with a trusted friend or relation. And of course, the solicitor will keep a copy of it. But it's important to keep this will where it will be safe and uncompromised. And usually a will is read 7 days after the burial of the testator. 7 days after the burial of the testator, the will is read. So that is all about wills and codicils. It's been quite a long video. I might cut it into 2 or I might not. But whatever I do with it, you would see it on the channel. So don't forget to like this video. It's a very important video. It's something you should save and come back to watch I'm sure that you will learn a lot from it, and even from rewatching it. Please share it far and wide. In the next video, I'm going to show you a live copy of a will. That's not a real copy. That's not someone's will, because I can't use someone's will. But I'm going to show you, a sample copy that I have drafted. A sample copy, just sample, with fictitious names and gift clauses and whatever, just to show you the necessary clauses in a will and some of the things that we've talked about in this video. I hope that you watch it as well. I will see you in that video. Toodles.